we're here to help you keep or get your kids back. And if you'll just help us help you, we can have success. We're making this video today for parents who find themselves in the dependency system because the state has great concern for their children. We want parents to understand the various aspects of the dependency system that they're going to encounter as their case goes forward. So we want to talk about the courtroom experience, working with your attorney, case planning, visitation, and permanency.
Cases come to court when Children and Youth Services files a petition alleging that your child or children are dependent. And what that means is that generally, Children and Youth Services can file a petition alleging several different grounds, but the most common ground that they petition upon is to say that your children are without proper parental care and control. It's important for you to also understand that not all cases come into court. Some cases, the families are able to be helped outside of court, but in this particular segment, we're discussing cases that have actually been made to come to court by the filing of a petition. The role of a judge in a dependency case is to hear all of the evidence that is presented and listen to it in an unbiased fashion and make sure that everyone is treated fairly in the courtroom and that the judge hears all sides and listens to everyone's opinion. Generally speaking, the judge will hear evidence from Children and Youth Services Agency. The judge will also hear evidence from the parents' attorneys and will also listen to evidence from the guardian ad litem and from the child. After considering all of that evidence, including any exhibits or any other documents or any other witnesses that are presented, the judge will then be making a decision in accordance with what particular type of hearing that they're hearing at that time. The role of a parent in a court hearing is to participate. You want to work with your attorney to make sure that your voice is heard in court. Judges make the best decisions when we get to hear what parents have to say, and you do that by working with your attorney to be prepared and make sure that any issues that you have are brought before the court.
Hearings don't always last very long, so sometimes you have a very short amount of time to get all the information in front of the judge that he or she is going to need to make the decision. So it's really important that you talk with your lawyer ahead of the hearing and make a game plan. What do we want the judge to know?
An important tip I would have for parents is that they want to make sure that they've reached out and their attorneys had the opportunity to sit down with them and have a detailed conversation about the plan for a particular court hearing. It's also important that you get to your court hearing early, because that affords you the opportunity to talk to your attorney and let them know of any last-minute surprises or developments, hand over paperwork you may have accumulated to demonstrate your progress. So there's no substitute for being there, and being there early is always a safe and smart thing to do.
In the courtroom, you will see other participants as well as the judge. You will see the Children and Youth Services solicitor, which is really a big word to say, but that's the attorney that represents Children and Youth Services. That attorney will generally be asking questions of the Children and Youth Services caseworker. You will also see the Children and Youth caseworker and possibly their supervisor in the courtroom as well. Also in the courtroom, you will see a guardian ad litem. The guardian ad litem's role is to represent your child or children. They are to tell the court what is in the best interest of the child and also what the child wants. In certain circumstances, there can be another attorney that represents just the child's interests to the court. Also in the courtroom will be a parent's attorney. If there are more than one parent, there may be multiple parents' attorneys, in that each parent would be entitled to have representation that represents their particular interest in court. It's important for you to know if you cannot afford counsel that you are entitled to have an attorney appointed to you free of charge so that your interests may be represented. You also may see in the back of the courtroom or in another location what is called a court-appointed special advocate or a Caseworker. The Caseworker generally is appointed by the court to try to ascertain facts to help the court make a decision. You should also know that generally speaking, the hearings are not open to the public. If you see other participants in the courtroom other than what we've just discussed, and you don't recognize who that person is, you can discuss it with your counsel to make sure that only appropriate parties are in the courtroom.
My role as a master is I'll hear various cases involving shelter care hearings, adjudicatory hearings, dispositional hearings. There is a distinction between a master and a judge. A judge is an elected official where masters are not. Masters are employees, or in some instances, independent contractors that work for court administration.
Hearings typically start with the oath, and that's everybody's promise to the court that they're going to tell the truth to the court. The next thing that happens is the agency's attorney begins his case. And so they start by asking the Children and Youth Agency worker about what the issues in the case are. And then after the Children and Youth Agency worker testifies, everybody gets a chance to cross-examine. And cross-examination is where the attorneys for the other parties in the courtroom get to ask questions about what the agency worker just said. After that, a parent attorney will then have a decision about whether they need to put on evidence. Sometimes the parent attorney may decide, I just want to cross-examine the children and youth worker, but sometimes they may decide, I need to call some witnesses here. So they may call you, mom or dad, to testify to the court, or they may call other people who they think have important information that the judge needs to know. After all the parties have a chance to put on their testimony, the judge will make the decision.
I made sure I arrived to court on time, dressed appropriately, and the most important thing is I kept my cool. I didn't get upset. There were some times when I wanted to, but I depended on my advocate to, sometimes she say, we're okay, we're doing good, even though I thought that we were doing horribly, but I trusted her. And so I did everything possible. Like I said, I didn't cuss at anybody, I didn't roll my eyes, I didn't get an attitude, and I let my case speak for itself.
How you conduct yourself in court is really important. The judge is going to be watching the demeanor of everybody in the courtroom, and so it's really important to show the judge that you can stay calm and respectful throughout the case. Now, that is not always easy. Sometimes you're going to hear things as a parent that make you really upset. Court is inherently stressful, and sometimes it can get really upsetting and really stressful when you're in the courtroom. The most important thing to remember, and the thing I tell my clients before we go in the courtroom, is that you can control your own behavior and nobody else's.
The hearing officer or master at the conclusion of a hearing makes a recommendation. That recommendation, the desire of the hearing officer or master is to have that recommendation immediately following the hearing. Oftentimes it's impractical. Maybe there's a protracted, which means a lengthy hearing that can go for 2 hours, 3 hours. Sometimes a hearing can carry over to another day. So oftentimes it's impractical to have that recommendation out the same day. But the goal, the desire, is to make sure that a parent, a child, parties involved have that recommended order by the master or hearing officer the same day. So there are several types of hearings that a master or hearing officer or judge will hear. The first is a shelter care hearing. Shelter care hearing is also known as a 72-hour hearing. This type of hearing is critical because a child is taken into protective custody. And it's at this hearing where a judge, master, or hearing officer has to determine what's going to happen with the child, who's the child going to remain with until there is an adjudicatory hearing.
At an adjudicatory hearing, the judge is trying to decide whether the Children and Youth Agency has enough evidence to prove by fair and convincing evidence that your children haven't been provided with proper care by you. If the answer is yes, then the judge will adjudicate your children dependent. If the answer is no, then the judge will dismiss your case. Another type of hearing is a disposition hearing. This is often held directly after the adjudication hearing and may even be held at the same time as the adjudication hearing. At the disposition hearing, the judge is making a decision, what next? He makes decisions about what happens to your child. Can your child stay at home, or does your child need to stay in placement? He'll make decisions about what services your family needs, and he'll make decisions about what is in your child's best interest for the next few months.
The fourth type of hearing that occurs between a master hearing officer or judge is the initial permanency review hearing. It's at that hearing that the expectation is that the parents come prepared, again, with names of relatives, supports, all contacts that may not be a party to the proceeding, but can be a helpmate or an aid to the family. At this particular hearing, the judge or hearing officer will listen to evidence and make a determination as to whether the parent has made some sort of progress into alleviating whatever circumstances that brought them into the court. The judge or hearing officer will also be listening to see how compliant that parent is with whatever the prior recommendations were from the adjudicatory hearing. While it is the goal at all times for the court to reunify successfully the child or children with his or her particular parents, after 15 to 22 months, the agency must file for termination of parental rights.
Whatever the court recommends, do it. Don't get upset, don't fight it. I found that going to parenting classes from the perspective of a parent who is needy was very rewarding, to the point where I went, graduated, kept going back. And like I said, I didn't miss a single appointment. So the major thing for permanency is to do what the court expects. In fact, it wouldn't hurt to go above and beyond, because what I started to do, I actually sought out other groups I can go to. And that actually got into the court transcripts. And it looked very favorably upon my part.
You can trust your parent advocate if you feel like you can't trust anyone else.
A parent attorney works with parents who have children in the court system, and ultimately they serve three fundamental functions. First of all, a parent attorney counsels a parent, helps the parent to understand all of the intricacies of the legal process, what the terms mean, what the objectives mean, what the parent ultimately can do for themselves, what their rights are as parents, and how to advance those rights, and ultimately to set an objective. Your attorney works for you, and as a counselor, through that process of getting to know you, understand you and your situation, you're going to come up with a plan as to what that objective is for you as a parent, and how the attorney is going to help make it happen. The second role connects directly with that, which is how, once you've set the objectives, how the attorney is going to help represent you in the court proceeding as your court representative. Whether or not you should testify, how to address witnesses, evidence, potentially adverse evidence against you. Your attorney is a professional and dealing with the court and working with the judge to build a record that's favorable to you. Thirdly, they're your advocate. So if in between court hearings you feel as though you want to move your case forward through motion, or you want someone to be with you, as you probably should, at a CWAF meeting, a family service meeting, they're there to go with you, to advocate for you, to make sure that you're not alone in the process and that someone's there to speak for you and make your point clear.
it's very important to keep in contact with your attorney because they are your voice in this whole situation. You can have thoughts and feelings and, things that you want to express, but it's their job to express that for you and go for what's best for you and your children.
Some of your rights as a parent when your children are in CWEF placement is, first of all, the right to visit. You have a fundamental right to visit with your children. And the level of visits and the amount of structure that's placed on those visits, the limitation that's placed on those visits is something that you have to work out with the court. Your attorney is there to help make your case as to why you should have the least restrictive visits possible. You have the right to participate actively in the decisions as far as the placement of your children, that your relatives have a first in line position in terms of being considered for placement, and the agency has an obligation to investigate them before moving to stranger foster care. So it's important to get your relatives who you think would be appropriate possible placements involved in the process. You have a right to continue to participate in the medical and educational decision making for your child unless the court has very explicitly said otherwise. You should be at medical appointments, you should be being consulted as far as consents are concerned. You should be front and center in that process even if they're not still in your physical custody. Your rights remain intact until the court says otherwise. So it's important for you to continue to be involved. It's easy as parents to get lost in the background of a court proceeding, and again, that's why parent attorneys are such an important part of this process, to make sure you don't get forgotten about. You also have the right to be at and have adequate and fair notice of permanency hearings and also family planning sessions with your caseworker, where they're ultimately going to set up what the goals and objectives are that is being placed on you and everybody else in terms of what it's going to take to reunify your family. And you absolutely have the right to be there. And also, once the agency has set forth what those objectives and goals are, the agency has to help you and provide reasonable efforts, unless the court says otherwise for good reason, to assist you in achieving your goals. So the more involved you are and the more active you are, then the more likely you are to get the services that you are by law entitled to.
I call my attorney weekly. In fact, I probably was a pest. She never acted like it. A couple times we got to a disagreement, but I needed to vent. I needed to get it off my chest. She allowed me to do it. And at the same point, she did so and let me know how the procedure, and she used the information. I mean, everything I told her, she was able to bring it to court in my favor. So it helped my case a lot.
One of the things that would have made it a less overwhelming experience for me would have been if I would have been more prepared for court.
Case planning is the process of the parent and the family coming together to make a plan. They come together with the agency to make a plan for resolving the issues that brought them to the attention of the agency. Usually, case planning is really focused on child safety. What are the issues that are making the child unsafe in mom or dad's house, and how do we resolve them?
If a family needs to be accepted for services, we will be explaining to the family what that process looks like in developing a family service plan to help the child remain safely in their home.
Family group decision-making is an opportunity for families to enjoy a process where they receive help from a facilitator to talk about their issues and problems and strengths and concerns for their family. And then during that process, they have the opportunity to meet privately without the providers, to decide for themselves how they can support each other and help raise their family and children.
It's really important that parents understand that the case plan is part of the court proceeding. The judge will usually receive the case plan as evidence, and then at every hearing, the judge will be asking the agency and you, what progress has mom or dad made in meeting the goals on the case plan?
It is so important that we hear your voice and know your choice in decision making. Not only is it the law, but it is best practice that we encourage you to invite those that know your family best to help and support you in developing your goals that will assist you in safely raising your children.
The caseworker helps the parent accomplish their goals by meeting with the families initially and identifying what their issues, problems, or concerns are. We have a meeting with the parents and the children. The agency is involved.
Anyone who a family identifies as a support or a connection to them, they are able to be a part of the case planning process. It's important for families to feel supported and like they have a team available to help them with achieving their goals.
I became aware that I couldn't navigate this on my own. I had to be humble enough to ask and reach out to people who I knew. If I was proud and if I was thinking I could do it myself, I'm not sure my children would have been returned.
A caseworker will help the parents accomplish their goals by making referrals, assisting in them contacting a provider, such as if there needs to be a drug and alcohol evaluation, the caseworker can help contact a drug and alcohol provider and help set up an intake appointment. They can refer them to other agencies, provide them with resources.
A caseworker absolutely will be held accountable if a parent is not meeting their goals, okay? That's the whole point of goal planning. My name is on that sheet just as well as the parent's name, the outside agency's name, the child's name. The parent has a goal, the caseworker has a goal.
When this first started, I did feel a little bit intimidated by my CYF caseworker. I did see her as some kind of enemy, but once I realized that she was there for a reason, I had to own up to everything that I did. It's not like I was being a great mom one day and they just walked in and got involved. So I had to see the part that I played in it.
What I tell parents is work with me, let's solve the problem. If you don't work with me and you resist me, you not open the door, not answer my phone call, this could lead to court. And you don't want to go to court because once it's in court, it's out of my hands. It's out of your hands. It's up to the master or the judge.
Going through this process and seeing the person that I'm becoming and the growing that I'm doing makes me realize that everybody was not out to get me. And in result, I'm a much better parent.
When you're in your case plan meeting, this is the time to ask for the help that you need. So if the agency is giving you a goal, it's really important that you tell the agency, I'm going to need help with that goal. So for instance, if the agency is having you do visits as one of your goals, which is an incredibly important goal, you can ask the agency for help with transportation or help setting up a visit at a time that doesn't conflict with your work schedule. It's just incredibly important that you use the case planning process as an opportunity to say what you need help with to get your goals accomplished.
My caseworker helped me meet the goals by well, first I had to communicate with her. I had to tell her, like, I'm struggling here, or I feel like this isn't going the way that I would like it to. And the more I communicated with her, the more research she would do for me, or she'd find different workshops or things for me to read. She had a lot of information.
As a parent involved in a dependency proceeding, you're going to get a lot of documents, and it can be really confusing to identify what document is what. One document you'll get is your case plan, and sometimes that has different names. It may be called a single case plan, it may be called a family service plan, and you should be familiar with what your county uses as their term. Another document you will have is your child permanency plan. Another document you may have is your court order, and actually you should make sure that you have all your court orders in one place and that you know what they say. And a final document you may see is a safety plan, and that's a plan that you're making with the agency to keep your child safe. The documents that are going to come up most in court are the court order and your case plan.
Ask questions. If there's something that you read in your case plan, you don't understand it, you call your CYF caseworker, call your parent advocate, make sure that you understand everything that's going on.
I didn't understand everything in that court order. The wording was unfamiliar to me, so I contacted my lawyer about any questions that I had.
Ultimately, if you don't understand something about your case, if you don't understand the objectives that have been set for you or why a particular objective has been set for you, ask and make sure you have that conversation. Because if you don't understand it, then there's no real way you're going to be likely to achieve it.
It's really important to keep track of your progress on meeting your goals. So you're going to be given a long list of goals to accomplish, and at every hearing the judge is going to be reviewing how did you do in accomplishing those goals. At that point, it becomes so critical that you're getting the documentation of your completion of your programs. So you need to make sure that you have evidence that you've done whatever goals the judge has asked you to do. So that's where the magic folder comes in. I love it when my clients come to court with this folder of all the documents that are evidence to show to the judge what they've done to meet their case plan goals. So if you have a parenting class, make sure at the conclusion of that class that you get your certificate. That certificate is going to need to be shown to the judge. If you have a drug and alcohol treatment program, make sure you get your certificate from your program or a letter from your treatment provider saying that yes, mom or dad has been going to their treatment program. That folder of documents is so critical when you go to court because the judge is not going to want to just hear testimony that you're doing these things. He or she is going to want to see hard evidence that you're doing them.
Nobody knows you better than you know yourself. When I was working on my case plan with my CYF caseworker, I let her know my strengths, my weaknesses, how I wanted to see me and my son's situation play out, but most importantly, what was best for him.
When I first started going to visits, I was very nervous. I didn't know what to expect. I didn't know what my role was, and I felt very uncomfortable. And I remember having a hard time adjusting to the visits because I was accustomed to my children being under my care and being in my home. And I wondered, can I discipline them? Can I bring them food? And how are they going to treat me, my children? So I think one of the tips I would give a parent is just to relax. Go into it knowing that you're the parent, that's still your role, that your children love you, they want to be with you, and if you are just natural and be yourself, you'll be successful in your visits.
We want unsupervised visits as often as possible. That's really the best form of a visit, the unsupervised visit, when the parent, the child, or the children can interact in a natural setting. So we encourage and we try to get our clients unsupervised visits right from the beginning of the case. And there's certain factors that a judge is going to look at in order to determine when reunification should occur, when reunification can occur. And the judge is going to get a report as to the visits. The judge is going to get a report as to the quality of the visits, how often the visits occur, your interaction with your children at the visits.
Visitation is important from a judge's perspective because the judge is overseeing the efforts to reunify the family. So visitation is the highest factor to help us determine when reunification can occur. So we want to promote visitation and understand it and make sure it's occurring for this family.
If things are going well regarding your visits, the first thing to do is contact the caseworker, see if the caseworker will expand your visits on their own. If not, contact your attorney. Your attorney can file a motion. Sometimes an attorney can get back into court sooner than the next court date.
When parents have to come to a visit ongoing, say once a week or twice or even 3 times, you want to make something memorable about each visit so a child can be thinking of that for the next time or during the week when they're not with you. So having a routine to entrance and exit, or a favorite book you read, or even we encourage some parents to have sort of a handshake at the end of a visit, something that is just between them and the child. It helps the child to think about their parent. It also helps their parents give them something that they can take with them when they're gone.
If they're not demonstrating a regular commitment to their child through visitation, it's hard to show to the court and to the agency that they are really intent on reunifying with their child. Visitation not only tells the agency, it tells their child they want to be with them.
Visitation, it was great because my dad, he would come every week. He'd bring movies, cut my hair, sometimes he'd bring snacks. I just like being offered a program of spending time with my dad.
One of the things that I learned was that the children really look forward to the visits, and if I bring them something, anything that seems to excite them and shows them that I'm thinking about them when we're apart. Maybe it's a holiday, and so you bring a present. But you know, when my children were returned to my care and I began to just readjust to life, caring for them, their needs again, you know, one of the things I learned was how important those little gifts and stuffed animals and things that I brought really mattered to them.
Judges must ensure that siblings have visits first by knowing who are the siblings. And sometimes those siblings are minor age, sometimes they're older, 18, 19, young adults. And so it's very, very important that we know the family to know what the sibling relationships have been and then make sure they're seeing one another because they're grieving that loss. It's traumatic for them to lose their parents as well as their siblings.
It's worth it to put effort into the visitation. It's worth it to make that commitment regardless of anything else going on in your life, any other crisis that you're facing. Just show up. That's the advice I have to give. Just be there for your kids. They need you. You know, when your children are taken from your care and your house is quiet and it's empty and you miss the sound of your children's voices and you wonder, are they even coming home? You think, has anybody else ever gone through this? And you feel very lonely, you feel scared, you feel very uncertain, and you wonder, what do I need to do? You know, how do I get them back?
What I want parents to know about the word permanency is that when they hear it, don't be afraid. Permanency can seem like a really scary concept, but what it means is that we want to see your child reunify with you. The court wants to see your child go safely home. Your child probably wants to go safely home, and you want your child to go home. The goal typically for the first part of their case is reunification, but they don't have a long time to get to that goal. Sometimes it can seem like a long time, but the reality is the time goes by so quickly. So it's incredibly important that parents stay focused on getting done what they need to get done so that they can get to their goal of reunification as quickly as possible.
The Adoption and Safe Families Act is the federal law that guides the court and the agency in their work with you. And what it means for you as a parent is a number of things. First of all, it means that we need to focus on keeping your child safe. Second thing that it means for you is that your child needs permanency. That's that lifelong family that every child needs and deserves. And permanency needs to be achieved quickly. So the Adoption and Safe Families Act sets up pretty strict timelines for you to work on the problems that brought you to our system. If your child has been in foster care for 15 months in a row, or for 15 out of the last 22 months, the Adoption and Safe Families Act requires that the agency file a petition to terminate your parental rights and seek to have your child adopted by another caregiver who can provide that permanency that your child needs. So that 15 out of 22 month rule is a really important one for you to be aware of and to understand. There are 5 permanency options, so 5 ways that your child can achieve that lifelong family that all children need and deserve. The first of those, and the most desirable, is reunification. So that's where the child returns to a parent who's safe, who can provide that lifelong family for the child. If reunification is not achievable, then the second best choice is adoption. Adoption is the option where 1 or 2 adults adopt the child, provide that lifelong family, become the child's legal parents, and the court case can close because the child has achieved a family that can meet their needs and keep them safe. If adoption is not the right option for the child, then the third choice is called permanent legal custody. That's an option where an adult caregiver is willing to take legal responsibility to raise the child until the child becomes an adult and to provide that lifelong family. So the caregiver accepts legal custody, the agency does not need to be involved any longer, and the court closes the case as well. The fourth option is called placement with a fit and willing relative. This option is an option that includes placing the child with a relative, and that's the person who makes a commitment to keep the child in their home as part of their family until they're an adult. But that caregiver isn't willing to take legal responsibility for raising the child. And so with that option, the court case actually will stay open, the agency will stay involved, but the child at least knows that he or she is in that lifelong family who's made the emotional commitment to keep that child in their family. And then the final option is called Alternative Planned Permanent Living Arrangement, APLA. That option is only available for children who are 16 or over. It's really the least desirable of our permanency options. We're still very focused on that child or older youth achieving lifelong connections with a family. It may be a family who they're living with, who has made the commitment that they can stay in their home, but this may also be a child who, for one reason or another, is just not able to live in a family. And so they may be living in a group home, they may be living in an apartment, an independent living arrangement, and then we're going to be focused on making sure that that child has lifelong connections with adults who care about them, even if the child is not living in that adult's family.
One thing that confuses some of my clients is about the 15-month rule is the idea that maybe their child has to stay in care for 15 months. That's not true at all. What the law says is as soon as the child can safely be reunified and it's in her best interest to go home, she can go home. So a lot of my clients reunify way faster than 15 months. I've seen moms get their children back in 4 months, in 6 months, in 9 months. The reality is judges want to send kids home as quickly as they possibly can as long as they know it's safe. So if you're in court and hear this word compelling reason, they're talking about maybe there's a reason in your case to keep the goal at reunification and not move to termination of parental rights. One confusing thing about compelling reason is that it's not very clearly defined in the law, and it is often very much contingent on the best interest of your child. So the judge is going to be looking at, is it in the best interest of this child to keep the case goal at reunification? It's important to know that there's a new law in Pennsylvania, which is sometimes called Act 101 or sometimes called the Post-Adoption Contact Agreement Law, that lets the judge make an order for you to have contact with your child after adoption. This would require the consent of the judge as well as the agreement of the adoptive parent. If you think that one of those orders would be in the best interest of your child, be sure to talk to your attorney about whether that's a possibility in your case. A concurrent plan is a backup plan for your child. In most cases, reunification is the primary plan and goal for your child, but the law requires that the Children and Youth Agency have a concurrent plan for your child. So that's the plan for in the event that the primary plan of reunification doesn't work out. Often you'll hear that adoption or permanent legal custody is the concurrent plan for your child.
The one thing that I would say to you as a parent whose child has just entered foster care is to stay focused on your child's needs for you to solve the problems that cause the child to enter placement, your child's need to stay connected to you, and your child's need for a permanent, lifelong family.
Have hope that things can change. The system is not about holding on to your children. The system is about trying to help you understand that you can change and you can make things different. It's hard work and only you can do it, but there are lots of support systems out there for you. And those support systems are in the providers, in the caseworkers, in the people who are trying to assist you to find where that change can happen to make you just a little bit stronger every day. You don't have to make all the changes at one time. One step at a time. Be a little bit better every day. And before you know it, things look brighter.
There's some times when I thought that it was done, we were losing. It brought me closer to my son because it enabled me to listen to him more. Not to say I still do a good job of it, but I'm a lot better because I saw things from his perspective. And also it gave me a better trust in myself. It showed me what I am capable of doing. Some things that I thought I wouldn't be able to do, I did it, and I'm here, So I'm not gonna say I survived, I thrived, In fact, as weird as it might say, I'm actually glad the experience happened. It's made me a better person, a better man, better husband, a better father.
Make sure that you understand everything that's going on.
Parents need to accept your decision making to start the situation. It's not the children's fault.
Recognize that this is an opportunity to learn and grow from this circumstance.
Never give up. Never. Keep fighting.